Welcome back to The Explainer. We are absolutely pumped for today's topic. We're putting on our legal educator hats to act as your personal tour guides for a global journey. Today we're unpacking comparative federalism. We're going to demystify exactly what happens when a country has to share power between its central government and its regional states. And trust me, it is way more dramatic and fascinating than it sounds.
To do this, we're pulling right from the syllabus of our source material. Specifically, Module 4, Federalism and its changing contours under various jurisdictions. We're not just looking at one country in a vacuum here. We're going to see how this high-stakes legal framework shifts, bends, and literally, sometimes even breaks, depending on where you are in the world.
All right, here is our flight itinerary for today. First, the hook. Second, the federal heavyweights. Third, the unique cases. And finally, why this is not a one-size-fits-all concept. Let's get moving.
Section 1. The hook. The ultimate power-sharing agreement. So where does this all start? Well, the word federation actually comes from the Latin word fedus, which translates to treaty. For a state to truly be federal, it needs a rigid written constitution that can't just be changed by one side on a whim, plus an independent judiciary to act as the referee. The renowned academic K.C. Weir defined this treaty perfectly. He said it's a method of dividing power so that both the central government and the regional governments are coordinate and independent. Basically, the center and the regions are absolute equals as long as they stay in their own lanes.
But that brings us to the central mystery of today's explainer. Think about it. If federalism is just a single academic concept, a treaty of shared power, why on earth does every single country do it so differently? Well, it comes down to history, culture, and sheer survival. Nations don't just adopt federalism in a vacuum. They custom-fit this framework out of absolute necessity to survive their own unique geographic, cultural, or historical crises.
Section 2. The federal heavyweights, USA, India, and Germany. Let's start with the classic, bottom-up model most people picture when they hear the word. The U.S. Constitution of 1787 is pretty much the epitome of classical federalism. It started with independent states voluntarily coming together, initially keeping the central government quite weak. From 1787 all the way to 1937, the U.S. operated under what's called dual federalism, where the federal and state governments stayed in strictly separate lanes. But then, massive crises hit. The Great Depression, World War II. These forced a dramatic shift toward cooperative federalism. The center and the states literally had to start solving common problems together, which led to a massive expansion of central federal power to create the modern welfare state.
Now, just because there's shared problem-solving doesn't mean the tension disappeared. No way. The U.S. system is completely defined by its elasticity. The federal government has delegated powers like declaring war and implied powers via the elastic clause. But on the other side of that legal tug-of-war is the 10th Amendment, which reserves immense power for the states, covering health, safety, and welfare. The Supreme Court constantly has to referee this. Historically, cases like Gibbons v. Ogden strengthen the center. But looking at modern constitutional law, the long history of Roe v. Wade and its subsequent overturn in Dobbs perfectly highlight this ongoing intense elasticity and the perpetual, everyday tension over states' rights.
Now let's contrast that American coming-together origin story with our next heavyweight, India. If the USA came together, India moved in the exact reverse direction. Because of its incredibly vast territory and amazing diversity, India transitioned from a unitary, top-down system under the Government of India Act of 1935 into a federal one. This unitary lineage means India was born with a very strong central bias, simply to keep the massive nation unified from day one.
And yet, there's a massive constitutional silence here. Get this, the word federalism isn't actually mentioned anywhere in the Indian Constitution. Academic K.C. Weir called this complex three-tier system quasi-federal. So what happens when the union and the states clash over who gets to make a law, which is governed by Articles 246 and 254? The courts step in using doctrines like pith and substance. In plain English, the courts look at the true core of a law to decide whose jurisdiction it actually falls under. It's just a brilliant example of highly customized cooperative federalism.
Okay, our third heavyweight, Germany, slices the pie completely differently. In the US and India, the center and the states both make and enforce their own laws. But under Germany's 1949 Basic Law, the Federation, or the Bund, dominates the making of the legislation. Meanwhile, the 16 regional territories, the Länder, dominate the administration of those laws. They're the ones actually handling education, police, and collecting the majority of the taxes.
Because of this unique split, Germany's system acts a bit like constitutional marriage counseling. It relies heavily on deep political consultation. The Länder are represented in the upper house, the Bundesrat, Before a draft bill is even finalized by the main parliament, the Bundestag, there are strict mediation proceedings. The center and the regions literally have to sit down and hash it out. And if they can't agree, the Federal Constitutional Court steps in as the strict guardian of this highly coordinated system. Section 3. The unique cases. Switzerland, Canada, and Belgium.
20%. In Switzerland, the central government controls only about 20% of the overall public budget. It's one of the most extremely decentralized countries in the entire world. Born out of a civil war in 1848, Switzerland uses federalism to protect intensely segmented linguistic and cultural minorities. The real power is held by the 26 cantons and 2,500 communes. Between their consensus democracy and heavy use of direct democracy referendums, the regions and the people truly hold the reins.
Next up is Canada, formed in 1867. Its history is best described as a giant legal seesaw. It was initially designed by Prime Minister John A. Macdonald to have a very strong center. Why? Because he was watching the American Civil War unfold right next door and was terrified of giving regions too much power. But over time, the Judicial Privy Council decentralized power toward the provinces. Then, the World Wars centralized it again for the sake of the economy. Then, in the 1960s, a surge of decentralization hit, largely driven by the French-Canadian majority in Quebec demanding autonomy. It's just a constant shifting balance.
Despite this seesaw effect, the Canadian central government still retains its overarching grip through a fascinating constitutional tool called the POG power. That stands for Peace, Order, and Good Governance. This power essentially provides three unique legal safety nets. First, the gap branch for matters not mentioned in the Constitution. Second, the emergency branch for times of crisis. And third, the national concern branch. Together, they ensure the center can always maintain stability when things get rocky.
And finally, we arrive at perhaps the most mind-bending trajectory of all, Belgium. Most federations involve states coming together, or a massive country decentralizing for efficiency. But Belgium experienced disaggregation. Founded as a French-speaking unitary state in 1831, Belgium deliberately broke its centralized government apart. To survive severe linguistic and economic fractures between the Dutch-speaking Flemish and the French-speaking Walloons, they essentially snapped the cookie in half. Across 6 major reforms ending in 2012, they broke into highly autonomous regions just to keep the nation from entirely shattering. It's federalism used purely as a survival mechanism.
Section 4. The takeaway. Not a one-size-fits-all. If you remember only one thing from today's explainer, make it this. Whether you're the United States coming together to build a nation, India structuring a vast subcontinent from the top down, or Belgium deliberately breaking apart to avoid a civil collapse, federalism is a custom-tailored suit. The law bends and adapts to a nation's unique history, its cultural divides, and its crises, proving that the sharing of power is always an ongoing, flexible, living experiment.
So, knowing what you know now about dual lanes, cooperative mediation, and the legal seesaws of power, how does your local government fit into this global puzzle? The next time a new law is passed in your hometown, ask yourself, who actually has the power to make it, and who enforces it? Keep asking questions, keep looking at the structure behind the rules, and we will see you on the next explainer.